clerk, stenographer, whatever you would call her, the one that's sitting there going do on her little machine. I requested immediately the transcripts of the trial, and she waited over 30 days to provide them for me. And I requested, because they being the whoever the fuck they are, said, oh, she's out with shingles. So because that lady, whoever answered the phone, and I have her name, is in fact the official supervisor of the court stenographers, I requested the actual medical records, because she divulged of, yes, this is in fact medical leave, and this is the reason why, and she didn't supply me with that either. And I gave her, like 14 days. It was very gracious. But I wasn't supplied, most importantly, my transcripts to the file for the hearing, aka meeting. And I'm wondering, what is the lawful battle rate? Because it's them warring against me, a living woman, and her little offspring, as far as that is concerned, and not providing transcripts. Thank you. And we need to cut this off and start afresh and new, please, because
that's what we're doing now.
It's going to be driving me nuts.
We'll get that verbiage for you. No problem. I get it. No problem. Okay, Glenn, you ready for the Bevins?
Anytime you're ready. All I can say is for Mary Gail Storm is that you're in an admiralty court. They can do anything they want. And the real solution is to make it so they don't want to talk to you. And that's why I like Todd Duell and his stuff, because it makes it so they avoid you like the plague, because you're going to get them in jail. Anyways, go ahead, Lori.
This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who signed an oath to the de facto government. Please raise your hand, say your name, and state your position.
Mary Bridget O'Connor. I swore allegiance to the local.
You better not. I'm going to mute you in a sec.
Union. And that was it. And evidently that was to the Queen, unbeknownst to me, myself, and I.
Okay, you're lucky. You get a pass. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position.
Ditto. Do the same.
One last time. That's Ruby snoring, not me. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township, agency present?
Ditto. To the same.
Mary.
Again, unbeknownst to me.
Okay, good. This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. That was 3 times, and I usually open with a small prayer, which I don't have in front of me, so I will do it from memory. And it's, oh dear, oh Holy Father, please bless our meeting with eyes to see and ears to hear the information being presented with an open and caring and compassionate heart, for as it shall be done. Take it away, Glenn.
Okay, I'm just pulling up my PDF file. I thought I had that up, but I actually have just the appendix that's up. So I'm just looking for it right now.
Do you think that the reason for the delay maybe could be that they've gone for their Christmas vacations as well?
It was not really. It was. It's been probably about a month. They've had it for about a month. The clerks are there. There's clerks there all the time. Technically, the courts are open 24 hours a day, 7 days a week. And so the clerks, there's someone always there that deals with stuff. And I think that they're interested in it, but they're hoping that I'll file my petition for a writ of certiorari. But I think that if I don't file it, I think that they'll call it filed. And after my 4 months runs out, they'll send me a docketing letter. But so I'm going to go ahead and just send it in. And I took it as an opportunity to modify it. And so I figured, because there's some things I added in, actually. Yeah. So I'm just selecting the file I want to share. There we go. That's it right here. So this is my, and notice the other one said pursuant to Rule 11. This one just says petition for writ of certiorari. And notice this is something I've added into all of my stuff now. This is a dig at those fucking bar scum, the lawyers or the judges in the lower court. I'm not dead, and I'm not lost at sea. I've never been dead or lost at sea. And I'm not a surety for the Pope's minor estate, and I'm not representing the Pope's minor estate. And I'll show you the court cases that talk about that as part of this. Anyway, so I sign everything now. I've added that stuff in. I'm not dead or lost at sea. I've never been dead or lost at sea. Fucking assholes. So, and I worked these questions for review. I actually could have made more, but I wanted 17 because 17 is a very Masonic number. It's the letter Q in the alphabet. It's the 17th letter. And what's the name? Book of Esther is the 17th book in the Bible. Anyways, so is the 1871 Municipal Corporation, the 16 Stat 419, a law made by Congress respecting an establishment of religion? And an unconstitutional violation of Article 1, an amendment, because it comes from what is now the Vatican and introduces the Pope's Roman canon law into the United States of America. And the question number 2 is the minor estate a law made by Congress respecting an establishment of religion and an unconstitutional violation of Article 1, an amendment, because it was created by the Pope's owned and operated Crown in England and with the Sister KV Act of 1666 and brought into the United States with the Code of Law for the District of Columbia in 1901 at 31 Stat 1432. Is the National Bar Foundation, Title 35 USC through 70501 through 70512, and all its subsidiaries in the various states, a law made by Congress respecting an establishment of religion, and an unconstitutional violation of Article 1, an amendment, because it's bringing the Pope's private bar guilt British accredited regency into the United States, which originated in the Pope's owned and operated city of London, and they're claiming immunity under the International Organization Immunities Act of 1945. And then this is one I added in. Is the National Bar Foundation, Title 35, USC 70501 through 70512, and all its subsidiaries in the various states, a violation of Article 1 of the Definitive Treaty of Peace of 1783, which is the only article still in force under the treaty collection, which is the supreme law of the land under Article 6, Clause 2, because King George approved the Definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, evidencing he was approving it on behalf of the Pope. And because King George and the Pope's owned and operated Crown of England, quote, for himself, his heirs, and successors relinquishes all claims to the government propriety. Because propriety is talking about private businesses, which includes the bar. So that, I think I got the bar run off one way or the other. So I think I'm going to get a home run on this, I'll tell you, when I get this filed. Anyways, is the minor estate a violation of the organic law of the Declaration of Independence of 1776? He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation for imposing taxes on us without our consent, which is referencing the Pope and his Cestui Que Vie Act of 1666 as the reason for the War of Independence. Is it an unconstitutional violation of Article 1, Section 8, Clause 17? To use the minor estate, 31 CFR 363.6, and the Commerce Clause, Article 1, Section 8, Clause 3, to convert the petitioner's land from the land of Texas into the foreign District of Columbia when there is no evidence of Roman canon law commercial activity and no contract, as evidenced by the fact that the silver coin was converted to land and it was demanded to produce a bona fide contract with no response of any kind. Is a judgment by the 97th District Court that makes petitioner a minor estate, 31 CFR 363.6, a bill of pains and penalties, violation of the Bills of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. Is a judgment by the 97th District Court that makes a petitioner a minor estate, 31 CFR 363.6, by presuming incapacity without adjudication, a denial of due process of law, under Article 5 an amendment, or a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1. I'll tell you, I could have made all sorts of more questions. That's 2 more questions right there I could have added. Actually, 1 more, a violation of the Equal Protection Clause. I could have made the same question and just made it a violation of the Equal Protection Clause. Is a judgment by the Northern District of Texas that makes a petitioner minor estate an unconstitutional bill of pains and penalties, violations of the Bills of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. Is a judgment by the Northern District of Texas that makes a petitioner a minor estate by presuming incapacity without adjudication, a denial of due process of law under Article 5 an amendment, or a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1. Is the refusal by the Federal Bureau of Investigation to investigate the 78 criminal complaints a denial of due process of law under Article 5 an amendment? Is the refusal by the Federal Bureau of Investigation to investigate the 78 criminal complaints a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1? Is the refusal by the U.S. Attorney to prosecute the 78 criminal complaints a denial of due process of law under Article 5 an amendment, or a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1? Is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the Bar Member Controller of Texas to authorize the County of Montague Municipal Corporation to make the petitioner a minor estate, to render by force the petitioner's land for taxation, to justify the theft of the petitioner's land, to extort fake money in support of their communist agenda, to eliminate private property rights, because the petitioner is a targeted individual, as evidenced by the targetedjustice.com website. Is the forced rendition by the petitioner's land of the petitioner's land for taxation by the County of Montague Municipal Corporation in conspiracy with the bar member controller of Texas a violation of the organic law of the Declaration of Independence? He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for imposing taxes on us without our consent, which is referencing the Pope and his KV Act of 1666 as the reason for the War of Independence. Is the findings, conclusions, and recommendation to the United States magistrate judge, which fails to be a findings of facts and conclusions of law, a legislative usurpation of the bench because it's involving a fiction of law, 31 CFR 363.6, which fails to exist under the Pope's ecclesiastical law, penalizing the petitioner, a named individual, with a non-judicial theft of land, and a bill of pains and penalties violation of the Bills of Attainder clauses under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. I think I'm creating a whole bunch of questions that they want to answer, I'm telling you. Is the findings, conclusions, and recommendations of the United States magistrate judge, which fails to be findings of facts and conclusions of law, of violations of the Equal Protection Clause of Article 4, Section 2, Clause 1, or a denial of due process of law under Article 5, an amendment by presuming incapacity without adjudication? So anyways, that's number 17. I had to keep them down to 17 because I wanted to have 17's a number that I like to keep them at. Anyway, so then this is the table of contents. And the table of authorities is next, which is all required by their rules. And all of this, I went through and verified all this stuff because I took a bunch of stuff out. I had to shrink it down. I needed to get it down to 39 pages. I added in a few things. I took some stuff out. So I had to check all of this stuff and make sure it was. As a matter of fact, I did make a bunch of changes to that. Okay, so this is the actual petition. The total number of pages in this thing is 334 pages, by the way. Okay, so the petitioner converted silver to land on the land of Texas in 2021 and stated on the face of the deed that the petitioner failed to be a Sesticate trust, a true copy of which is attached to the notice of objection to the findings, conclusions of the magistrate judge and motion to reconsider, which is attached to in the appendix at tabs 4, pages 111 and 112, all of which is incorporated herein by reference in its entirety. The County of Montague Appraisal District Municipal Corporation, under the direction of the Texas Controller in conspiracy with the Pope's private bar guild, converted the petitioner's land from the land of Texas to the Foreign District of Columbia under the Commerce Clause, Article 1, Section A, Clause 3, to render by force the petitioner's land, as evidenced by the General Real Property Rendition of Taxable Property Form 50-141, which is attached to the notice of objection to the findings and conclusions of the magistrate judge and motion to reconsider. That's attached here too in the appendix at tab 4, pages 113 to 114, all of which is incorporated herein by reference in its entirety. So, it was forced rendition is what they did under their code, render it for taxation. I was going to say something. Oh, the Texas Comptroller has resigned, by the way. Okay. And Greg Abbott came up to DFW giving public speeches about how they were going to stop property taxes and they're going to end property taxes in Texas. Well, that's a bunch of lie, for one thing. And number two, I think that he didn't want me to take this thing to the Supreme Court because they know they're going to lose. And so he wanted to, because he came up to the DFW area, he knows I'm around here somewhere. And I had a friend of mine that went, but I told him I'm not interested in going. I don't want to talk to him. He's an asshole. The County of Montague Municipal Corporation enslaved the petitioner with their minor estate at 31 CFR 363.6 with their tax notices, tax liens, threat letters, as evidenced by the delinquent tax statement that's attached to the Catherine Phillips notice and demand, that's attached to the notice of objection to the findings, conclusions, and recommendations of the magistrate judge and motion to reconsider, that's attached hereto in the appendix at tab 4, pages 92 through 110. Okay, so that's the Catherine Phillips notice and demand is there at 92 through 110. The petitioner served by registered mail a Catherine Phillips notice and demand to officials in the County of Montague Roman Canon Law Municipal Corporation, explaining they were engaged in multiple felonies and that the petitioner failed to be a Sisticae trust, and demanding that they produce a bona fide contract. In paragraph 43 at tab 4, page 103 to 104, quote, "And this notice and demand shall be evidence of your intent to engage in all of the crimes, including but not limited to those described herein. And it shall be further evidence that Clavey Riddle, Kim Jones, and Jennifer Finoglio and others intend to be your accomplices and co-conspirators, as well as your agreement that I file criminal complaints against all of you and bar grievances against all bar members in their private capacity and seek other remedies." Unquote.
I remember Michelle asking you about that in the early fall.
Sorry?
She heard that somebody in Texas was talking about dropping property taxes.
Yeah, that's Greg Abbott. He's the governor. The military governor, I might add. The County of Montague Roman Canon Law Municipal Corporation got the Pope's private bar guild members to file a tax suit on behalf of Bowie Independent School District in the 97th District Court before the Pope's Patricia Coleman buyers, as evidenced by the judgment that's attached in the notice of objection to the findings and conclusions of the magistrate judge and motion to reconsider, that's attached hereto in the appendix at tab 4, pages 15 to 17, all of which is incorporated herein by reference in its entirety. The petitioner filed 78 criminal complaints into the case and sent them to the Federal Bureau of Investigation, and the United States Attorney and the weaponized Department of Justice ignored them, as well as the fake judge, as evidenced by the demand to disqualify the judge, a true copy of which is attached hereto in appendix at tab 1, all of which is incorporated herein by reference in its entirety. The petitioner filed a petition for a writ of mandamus for the Second Court of Appeals to order the lower court to prove standing and jurisdiction, as the Second Court of Appeals refused to accept it because the petitioner is a quote-unquote vexatious litigant, evidencing their intent to deny the petitioner due process of law, as evidenced by the clerk's letters, true copies of which are attached hereto in the appendix at tab 2, all of each of which are incorporated herein by reference in their entirety. The petitioner brought the case to a common law jury. Our one Supreme Court talked about in Article 3, Section 1, the judicial power of the United States shall be invested in one Supreme Court, emphasis added, which issued an affidavit of findings of fact, a true copy of which is attached to the appendix at tab 12. The Pope's clerks, masquerading as judges in the 97th District Court, subjected the petitioner to their star chamber with their forced legal counsel on their refusal of a challenge to jurisdiction, pages 118 to 135, as evidenced by their return mail at pages 137 to 138, and issued a bill of pains and penalties, similar to a bill of attainder, with their legislative act against the petitioner. The named individual made the petitioner to the Pope's minor estate to justify the theft of the petitioner's land by the County of Montague and their private bar guild handlers, and enslaved the petitioner for their Vatican handlers at page 115 to 117, and they were in the process of unlawfully selling the petitioner's land when on the day of the sale, the petitioner set off their extortion with Federal Reserve no commercial paper fake money that are only for use in the Pope's foreign owned and operated Roman Canon Law Municipal Corporation in the District of Columbia. And this is Gold Reserve Act of 1934 at 48 Stat 337. As used in this act, the term United States means the government of the United States. The term United States The term currency of the United States means currency which is legal tender in the government of the United States and includes United States notes and Federal Reserve notes. Evidencing they were in the second national government talked about in the dissenting opinion of Downs versus Bidwell, maintained by Congress outside and independently of that instrument. Two national governments exist, one to be maintained by Congress under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's dissenting opinion of Justice Marshall Harlan, Downs versus Bidwell, 1901. And I just want to check YouTube. Oh, wow. So why is it doing that? That's weird. Yeah, you're right. My screen needs to be fixed. I'm trying to figure out what's going on and why it's doing that.
Is it shuffling or something? It's looking fine on this side, but it sounds on the thing.
I know what it is. Okay. It's a long story. Window capture. Okay. There we go. Let's make sure it goes through on YouTube. I fixed it. It should show up there on YouTube in a minute. There we go. Okay, I got it fixed. So we're on page 3, so you guys didn't miss much. We missed basically the questions for review and the table of contents, basically. All of which is evidenced in the returned challenge to jurisdiction and attorney's fees ordered on page 141, which is attached to the Catherine Phillips notice and demand. That's attached to the notice of objection to the conclusions, findings, and conclusions of the magistrate judge and motion to reconsider, which is attached here to in the appendix at tab 4, all of which is incorporated by reference in its entirety. I really had to massage this thing to get it to where it was under 40 pages. I'll tell you, I really did. And right now I'm printing it up, and I'm going to have my 10, but then I got to serve a bunch of them, so I got to make another, I'm thinking probably about another 6 or 7 to serve. Anyways, the petitioner has never in his life breached the peace, but the weaponized Federal Bureau of Investigation, military police refused to investigate the felonies of the weaponized United States attorney, refused to prosecute the felonies, and that the County of Montague Roman Canon Law Municipal Corporation and conspiracy of the Pope's private bar guild members had engaged in support of their weaponized Department of Justice and their communist handlers to implement the first plank of the Communist Manifesto, the abolition of private property rights. All this originated with the Roman Canon Law Municipal Corporation established by Congress at 16 Stat 419 that is now owned and operated by the Pope. The petitioner filed a lawsuit in the Fort Worth Federal Court, and they issued the findings, conclusions, and recommendations of the United States Magistrate Judge, which is attached here to an appendix at tab 3, which fails to be the required findings of fact and conclusions of law, which it means it has nothing to do with facts or law, which means they're legislating from the bench, and it's a bill of pains and penalties, which is a bill of attainder violation under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, a true copy of which is attached here to in the appendix at tab 3. The petitioner filed document 104, notice of objection to the magistrate judge findings and conclusions and recommendations and motion to reconsider, a true copy of which is attached here to in the appendix at tab 4. The court filed an order accepting findings, conclusions, and recommendations of the United States Magistrate Judge. Tab 5. The court filed a final judgment at tab 6. The petitioner filed a notice of appeal on March 3rd to the U.S. Court of Appeals, case 25-10360, a true copy of which is attached here to at tab 7. The petitioner filed document 108, notice of constitutional challenge, because they're obviously making the petitioner their minor estate, and it failed to matter what the petitioner said or did, a true copy of which is attached here to in the appendix of tab 8. The petitioner filed document 112, mandatory judicial notice of 12 presumptions, because they're obviously making the petitioner their minor estate, and it failed to matter what the petitioner said or did. The petitioner filed document 113, affidavit of life, because they're obviously making the petitioner their minor estate, and it failed to matter what the petitioner said or did. At tab 10. The petitioner filed document 114, notice of void judgment. Tab 11. The U.S. Court of Appeals for the Fifth Circuit affirmed the decision of the district court at tab 13. So you have to understand that they're only going to argue stuff that was brought up on the appeal. Okay, in other words, the magistrate judge made they converted me into the slave. And I didn't even answer any of their stuff because they're converting me into the slave. They wanted to force me to try and argue their slave arguments. And I didn't. And so the Court of Appeals said basically the same. He didn't argue anything that the magistrate judgment said. And so that's what they said. And they were right. I didn't. Statement of jurisdiction. Article 1, Section 1 of this Constitution for the United States of America, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. All legislative powers. And Article 1, Section 8, Clause 9 says to constitute tribunals inferior to the Supreme Court. And since this court was created by the Judiciary Act at 1 Stat 77, the one Supreme Court talked about in Article 1, Section 8, Clause 9 and Article 3 can only be talking about a common law court that existed prior to the Constitution, because this court is a legislative inferior court created under Article 1, Section 8, Clause 9. This petition for a writ of certiorari is brought pursuant to Article 3 of the Constitution. This action should be a petition for a writ of error, but your clerks insist on calling it a certiorari under color of law, which is subjected to on and for the record. This action was brought in the lower courts because of an act of the United States Congress, because taxation of the land originated with an act of Congress approved August 5th, 1861 at 12 Stat 292 that has not been repealed or modified. That provided for tax assessors and collectors is Section 9, 12 Stat 296, required to execute a bond, Section 10, 12 Stat 296, have an oath of office, Section 11, 12 Stat 297, Secretary of the Treasury to provide regulations at Section 12, 12 Stat 297, a direct tax on lands and lots of ground at Section 13 at 12 Stat 297, a Board of Assessors at Section 25, 12 Stat 300, tax liens, Section 33 at 12 Stat 303, every collector shall exercise or be guilty of any extortion or oppression under color of this act shall be liable, Section 43 at 12 Stat 307, a penalty for taking a false oath, perjury of oath, Section 47, 12 Stat 308, and there shall be allowed in full compensation for their services a commission. They get a piece of the action. They're a bunch of fucking thieves. Section 48, 12 Stat 308. This action has national importance due to the fact that almost every city, town, county, state, and the union are now operating the Pope's Roman canon law municipal corporations, and the Pope's private bar guild are presuming all of the people, if not all of the people in this country, are the Pope's minor estate, all of which is evidenced by the weaponized courts that Trump is trying to get rid of with his weaponization working group in the Department of Justice. Constitutional and statutory issues involved. The 1871 municipal corporation created by Congress at 16 Stat 419, the minor estate at 31 CFR 363.6, and the foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, USC 70501 through 70512, are each unconstitutional violations of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because it's a law respecting the Pope and the Vatican and the Holy See, and also because they're busy subjecting the petitioner and the people of this country to their Roman Catholic Roman canon law, satanic religious ceremony with their fraud, deception, lies, idolatry, necromancy, and violation of the petitioner's sincerely held Christian religious beliefs. The foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, USC 70501 and through 70512, is also a violation of Article 1 of the Definitive Treaty of Peace of 1783, which is the only article still in effect under the treaty collection, which makes it supreme law of the land under Article 6, Clause 2, and therefore a constitutional violation. The judgment of the 97th District Court, as well as the judgment of the Northern District of Texas, are each a bill of pains and penalties, are prohibited under the Bills of Attainder clauses of the U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. They're bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section A, Clause 17. So any of you on YouTube, good, I'm glad you're getting it. You can do super chats. They're available. I set that all up. So if you have any questions you want me to ask, I'll be glad to do it. Just send a super chat. Anyways, so I'll be keeping my eyes open for that. Statement of the case. The petitioner's posterity. The petitioner's mother and father were joined in the state of holy matrimony at the time the petitioner was born to them, and all of his ancestors were joined in the state of holy matrimony as evidenced by the statement of original status in the affidavit of corporate denial. It's recorded with the Pinal County Recorder at fee number 2013 032373 and the pedigree charts that are attached thereto. That is now the unrebutted truth and public policy, which may be viewed at their website. And Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey, 1787, is the petitioner's fourth great uncle, which means the petitioner's posterity is found in the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America. And the petitioner is entitled to right of blood. And right of blood cannot be destroyed by any civil law, because all the laws of Congress after 1871 and all the laws of Texas after the Civil War are civil laws. And this is Bouvier's Law Dictionary, 1856 edition, Volume 2, page 132. It's a maxim of law. The right of blood and kindred cannot be destroyed by any civil law. And this court is operating under power which is derived from the petitioner as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. Bouvier's Law Dictionary, 1856 edition, Volume 2, page 127. Therefore, it's impossible for the petitioner to give the County of Montague or their private bar guild handlers or this court any authority over the petitioner, and the Legislative Inferior Supreme Court of the United States agreed and said it's impossible to confer a sovereignty which will extend over the petitioner. And this is McCullough versus Maryland, U.S. Supreme Court, I think it's 1815. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers carried on by that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of that Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. Let's see. Somebody send something. Okay. Keep moving here. Just looking at the chat on YouTube. The petitioner is exempt from the County of Montag and the Pope's private bar guild, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the petitioner requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or their property belong to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding. That's Article 6, Clause 2, this Constitution for the United States of America. Fictions of law. Fictions of law were invented by the Roman praetors under the ecclesiastical canon law for the Pope's ecclesiastical city-states that are now the Vatican, under the pretense of doing equity. This is Bouvier's Law Dictionary, 1856 edition, Volume 1, page 520. Fictions of law were invented by the Roman praetors who not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fiction is the resource of weakness, which in order to obtain its object assumes a fact that is known to be contrary to truth. When the legislator decides to accomplish his object, he need not feign, he commands. Fictions of law owe their origins to the legislative usurpations of the bench. So when they're dealing with a fiction of law, they become a legislator. And fictions of law owe their origins to the legislative usurpations of the bench. The fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applies to named individuals to inflict punishment without a judicial trial. And this is U.S. versus Lovett, U.S. Supreme Court. Bill of attainder means a legislative act, no matter what their form, that apply either to named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. Bill of attainder, this is Black's Law Dictionary. Special legislative act prescribing punishment without a trial. Bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So a bill of attainder is capital punishment. Bill of pains and penalties are included in the U.S. Constitution's bans on bills of attainder, because judges only hold office during good behavior. The judges, both the Supreme and Inferior Court, shall hold their offices during good behavior. Article 3, Section 1. The judges in bad behavior, or fake judges, are engaged in fraud upon the court. Fraud upon the court is fraud which is directed to the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It's where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted. When a superior court of general jurisdiction undertakes anything in derogation of common law, it becomes an inferior court of limited jurisdiction for that proceeding only. It is familiar law that when a special statutory authority in derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quod hoc, which means for that proceeding only, a court of inferior or limited jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. And that's corpus juris secundum. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, A decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. And that's Book 20 of American Jurisprudence. Ecclesiastical Roman law is the Pope's clergy. The judges dealing with the Pope's minor estate, 31 CFR 3636.6, are the Pope's clergy. And this is Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of more main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, that's papal ingenuity. When they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. That's the Vatican, folks. Thus distinguishing between the possession and the use. And use is short for usufruct under Roman law. And receiving the actual profits while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to his sesticate use for the rents and emoluments of the estate. Well, that's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And engage in fraud upon the court in conspiracy with the Pope's private bar guild members working for the County of Montague Roman Canon Law Municipal Corporation when they issued a bill of pains and penalties against the petitioner, the named individual, to be accomplices to the theft of the petitioner's land by using the ecclesiastical fiction of law minor estate, sesticate usufruct, and the law of trusts, which are things and have no rights. Forced rendition. The County of Montague Roman Canon Law Municipal Corporation converted the petitioner's land from the land of Texas to the Pope's owned and operated foreign United States District of Columbia by rendering by force the petitioner's land, even though the Texas tax code originated after the Civil War, with an act defining what money and property is subject to taxation or exemption, and the mode of listing the same on August 21, 1876, being enacted by the legislature of the state of Texas that all real and personal property in this state, the property of corporations now existing or may hereafter created, and the property of all banks and banking companies now existing or may be hereafter created, and all bankers, except such as hereinafter expressly exempted, is subject to taxation, and such property or the value thereof shall be entered in a list of taxable property for that purpose, in a manner prescribed by this act, which is for corporate-owned property. In Section 4, the term person, whenever used in this act or any other act regulating the assessment or collection of taxes, shall be construed to include firm, company, or corporation, and requires cash or its equivalent for their taxes, which means Federal Reserve notes. Market value means the price of which property would transfer for cash or its equivalent. And as explained in the Catherine Phillips Notice and Demand, 06-1022, that was served on Montague County, that shows taxable land is used for the production of income. Rendition, property used for the production of income. That's Section 22.01, Texas Tax Code. And rendition originated with Section 7 in the Act of the Legislature of 1876. All property shall be listed or rendered in the manner following. For first, every person of full age and sound mind being a resident of this state, which is corporate property, which means the petitioner's land fails to qualify for rendition, as explained in the Notice and Demand that was served on the County of Montague, because income is corporate profits. And this is U.S. Supreme Court case Eisner versus McComber. It becomes essential to distinguishing between what is and what is not income, according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot, by legislation, alter the Constitution from which it derives its power to legislate, and from which, within those limitations alone, that power can be lawfully exercised. Income is derived from capital, the gain derived from capital. Hence we have the essential matter. Not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value separate from capital, however invested or employed, coming in and being derived, that is received or drawn by the recipient for his separate use, benefit, and disposal. That is income derived from property. Nothing else answers the description. And emphasis was in the original. So if you notice here, there's a bunch of underlining and bold, and that was all in the original. The Pope's ecclesiastical city-states in Italy. After the collapse of the Roman Empire, the Pope was absolute monarch of a group of ecclesiastical city-states on the Italian peninsula. Roman or papal states stretch across the central part of the Italian peninsula in the oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast area, 17,822 square miles. Population in 1833, 2,742,000. Capital Rome, population 153,000. Government and elected monarchy. The Pope, for the time being, absolute sovereign with a consulting assembly of cardinals. And that's Waterston, Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Rome, the capital of the Pope's territories and of Italy, anciently the Milrus of the Roman Empire. Encyclopedia Britannica. With the law being Roman law, was also called canon law, and ecclesiastical law, municipal law, and civil law. The laws of the municipia are dependent states. And this is Encyclopedia Britannica. Civil or municipal law is that law which every sovereign kingdom is appropriated to itself. The appellation of municipal was originally confined to the law of the municipia or dependent states. Canon law is a collection of ecclesiastical rules in the form of the civil. Canon law, body of canon law, collection of ecclesiastical rules, definitions, constitutions taken from the ancient councils, the writings of the fathers of the church, and the ordinances of the popes. This law is modeled according to the form of the civil. Contained in 3 particular volumes, the Decrees of Gratian, the Decretals, and the Sextum. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. And that's Black's Law Dictionary, 4th edition. The civil or Roman law is called canon law. And that's civil or canon laws, civil or Roman and canon law, Encyclopedia Britannica. And the Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, a year before the Pope's 1871 municipal corporation was enacted by Congress at 16 Stat 419. King John gave the kingdoms to the Pope in the year 1213. King John gave the kingdoms of England and Ireland to Pope Innocent III and agreed to rent them back for 1,000 marks sterling per year. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. And that's
please, may I? What year was that, please? I need to know this date, year. King John.
I will upload the Word file to my page on Weir Law. Then you can have that.
Awesome.
And the concessions of England to the Pope in the year 1213. This you can just look up. You do Google and pull this up. We will establish a perpetual obligation and concession. We will establish that from the proper and special revenues of our aforesaid kingdom, for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of Michael 500 marks, and at Easter 500 marks, 700 for the kingdom of England, and 300 for the kingdom of Ireland. Which means the Pope owns the kingdoms of England and Ireland, now known as the United Kingdom, the Crown, and the City of London. The Sesquive Act of 1666 caused the War of Independence. The Pope's dependent city-state, the City of London, called the Crown, created the Sesquive Act of 1666. And this one I've already read. This was from that one from Tomlin's Law Dictionary, 1835 edition. Who was held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to assist to use for the rents and emoluments of the estate. That's taxes. That's why that Todd duel is so brilliant, because it's all about accounting. Statutes have been passed extending courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which this despotism would reduce us, and that's cause of necessities for taking up arms, 1775. And the organic law, the Declaration of Independence, shows it was listed as reasons for a Declaration of Independence from the Pope's tyrant, the Crown of England. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, transporting us beyond seas to be tried for pretended offenses, imposing taxes on us without our consent, because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, the others is talking about the Pope, and the foreign jurisdiction is the Pope's ecclesiastical Roman civil law. And the definitive treaty of 1783, in the preamble, it says King George was arch-treasurer and prince-elector of the Holy Roman Empire, evidencing the Crown of England was owned and operated by the Pope. And as arch-treasurer and prince-elector of the Holy Roman Empire, he was authorized to make peace on behalf of the Pope, which is also why thousands of people were fleeing Europe at that time, because of the Pope's tyranny there, as talked about in John Locke's 2 treatises of government. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making use of power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law, but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion, 'tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put in any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those who use it are one or many. And that's John Locke, 2 Treatises of Government, Book 2, Chapter 18, Sections 199 and 201. With the Spanish Inquisition, Inquisition is one way of proceeding in ecclesiastical courts. And other inquisitions and oppressions they routinely engaged in to enrich the Vatican. This is Blackstone's commentaries. The use of information has a long history. For example, in the reign of Henry VIII, a very oppressive use was made by them for something more than a century, so as to continually harass and shamefully enrich the Pope's crown. Courts ecclesiastical. Spiritual courts is those courts which are held by the king's authority as the supreme governor of the church, for matters which chiefly governs religion. And the laws and constitutions whereby the Church of England are governed, diverse immemorial customs, our own provincial constitutions, and the canons made in convocations, especially those in the year 1603, much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. Gee, that sounds like what goes on today. And also why the petitioner's ancestors made the first article and amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they did not want it happening here. The Pope's pretended jurisdiction. Remember we talked about that? When they're talking about pretended legislation or pretended offenses in the Declaration of Independence, see here it says he's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. They're talking about the Pope's ecclesiastical Roman canon civil law. Law, canon. Canon law is the body of Roman ecclesiastical law relative to such matters the church has or either pretends to have the proper jurisdiction over. Canon law, a body of canon law, collection of ecclesiastical rules, definitions, and constitutions taken from ancient councils, the writings of the fathers of the church, the ordinances of the Pope. This law is modeled according to the form of the civil. There are lots of references in old law dictionaries to the Pope's pretended jurisdiction. Jesuits, born in the kingdoms and the king's dominions and ordained by the pretended jurisdiction of Rome. The oath of supremacy is principally calculated as a renunciation of the Pope's pretended authority. The Pope's private bar guild. The Pope's clergy operate under their ecclesiastical Roman civil law courts with the private bar guild, with bar being an acronym, stands for British Accredited Regency. Regency is the office or jurisdiction of a regent or body of regents, a government by authority of regents, a period during which a regent or body of regents governs. Black's Law Dictionary, 8th edition. Because the Pope's private bar guild clergy member are appointed by Inns of Court. Inns of Court, certain private unincorporated associations in nature of collegiate houses located in London, established and vested with the exclusive privilege of calling men to the bar. And that's Black's Law Dictionary, 5th edition. Which is located in a Pope's dependent city-state, located in the city of London, originally called the Kingdoms of England and Ireland, now known as the United Kingdom, and the Crown, since the concessions of England to the Pope, 1213, which means all private bar guild clergy members are foreign agents of the Crown, which is why they're here under the civil laws of Congress, the foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, U.S.C. 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945. And King George approved the definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, evidencing he was approving it on behalf of the Pope. And Article 1 of the definitive Treaty of Peace of 1783, which is the only article still in full force under the treaty collection, which makes it the supreme law of the land under Article 6, Clause 2, and because King George and the Pope's owned and operated Crown of England, for himself, his heirs, and successors relinquishes all claims to the government propriety, because propriety is talking about private businesses, which includes the bar, and is a violation of the Treaty of Peace of 1783, Article 1, as supreme law of the land under Article 6, Clause 2. The Pope was involved in the Civil War because the Pope's owner and operated Crown of England sent fleets of ships to attack Washington, D.C. and San Francisco in support of the Southern Confederacy. But the Russians sent fleets of ships to blockade the area in support of Lincoln. The judges in the lower court are private bar guild members as required by the civil laws of Congress. 28 U.S.C. 631, no individual may be appointed or reappointed to serve as a magistrate judge unless he's been at least 5 years a member in good standing at the bar of the highest court of a state, and have exposed themselves to be the Pope's clergy. In the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum and could not conduct business. And on the 15th of April, notice the date, 15th of April of 1861, under emergency and necessity and executive authority with Executive Order Number 1 at 12 Stat 1258, Lincoln ordered Congress to reconvene, and everything has been under executive authority ever since. 1871 Municipal Corporation. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, and the year prior to Congress's 1871 Municipal Corporation. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy, and are now called the Vatican City and the Holy See, and it continues to this day. This is Lateran Pact, Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as pertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. The Pope's ecclesiastical Roman canon law, Sestike Ius, was brought into the United States first with the Pope's 1871 Roman canon law municipal corporation at 16 Stat 419, because civil law, Roman law, municipal law are convertible phrases. Because municipal law was the law of the municipia, or dependent papal ecclesiastical city-states. The Pope's Minor Estate Act of 1666 was brought into the United States with the Code of Law for the District of Columbia in 1901, an act to establish a Code of Law for the District of Columbia, the legal estate to be the Sestike Ius, which is short for usufruct at 1617, 31 Stat 1432, which creates the presumption you are dead. At Chapter 3, absence of 7 years, Section 252, 31 Stat 1230, where it says presumption of death. He shall be presumed to be dead in any case wherein his death shall come in question, unless proof be made that he was alive within that time. And the Pope's Uniform Commercial Code, private international law under Unidroit, and this is the case to remember. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. That's why I say I'm not representing the Pope's minor estate, and I'm not a surety for the Pope's minor estate. And I'm not dead. For all you brain-dead, bought and paid for whores masquerading as judges that want to presume I'm dead, I'm not dead. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports the finding of its non-existence. The Pope's minor estate, Sestike Usufruct, is now codified at 31 CFR 363.6 and are unconstitutional because Article 1 Amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's necromancy, sestque usufruct, which is now called the minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. Entity means any owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, a professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who's failed to take control of the securities of the treasury direct account. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of securities contained in his or her minor account. And puts you under trust law, which is part of Roman canon law, and trusts are things and have no rights. The Pope's sestque minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity and owe their origin to the legislative usurpations of the bench. And that's Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. And the Pope's fictions of law are necromancy and satanic. There shall not be found among you anyone that maketh a son or daughter to pass through the fire, or that useth divination, or observer of times, or enchanter, or a witch, or a charmer, or a consultant of familiar spirits, or a wizard, or a necromancer. For all these things are an abomination unto the Lord. Because of these abominations the Lord thy God doth drive them out before thee. Deuteronomy 18:10-12. Puts you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17. To exercise exclusive jurisdiction in all cases whatsoever over such district not exceeding 10 miles square. There's two national governments, one under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And this is the dissenting opinion of Justice Marshall Harlan in Downs versus Bidwell. The Pope's quasi-contracts, they use fraud and deception to assault people with a quasi-contract, fake contract, assumpsit. In its origin, an action of tort, assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account. Remember, these are all commercial words. Case upon a bailment, a warranty, bills of exchange, competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They are contractual law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not reality fall within it. Which requires the Pope's fictional law, minor estate. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia, through their plenary power nationally, covers those citizens, even in one of the several states, as though the district expands for the purpose of regulating citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company, the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Because plenary power is a dictatorship under the Pope's Roman canon law. Let me check YouTube. Plenary, full, complete in the courts of admiralty, English ecclesiastical courts, causes or suits in respect of different course of proceedings, which are termed plenary or summary. Plenary or full, formal suits of those in proceedings must be full and formal. The term summary is applied to those cases where the proceedings are more succinct and less formal. Plenary, a plenary power or plenary authority is a complete and absolute power to take action on a particular issue with no limitations. is derived from the Latin term plenus. That's Wikipedia, but that's also quoting Legal Information Institute, which is Cornell Law School. Complete power of a particular area with no limitations. This term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. The courts in the lower courts are tyrants, operating as bought and paid for administrative legislative clerks, masquerading as judges. The Pope's clergy, under the Pope's canon law of trusts, in bad behavior and fraud upon the court, which are non-judicial proceedings, because whenever a statute's involved, the Pope's fake judge is actually a clerk masquerading as a judge as the Pope's clergy. When acting to enforce a statute and subsequent amendments to the present date, the judge in municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially. It's the accepted rule, not only in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. Judges have become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Which means they're legislators, engaged in legislative acts against the petitioner, the named individual, by using the minor estate, which is a fiction of law, was invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. Which means the fake judge for the 97th District Court and the fake judges in the United States District Court for the Northern District of Texas acted as legislators and issued a bill of pains and penalties against the petitioner, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law and ecclesiastical law, and they're also bringing District of Columbia outside a maximum 10-mile square in violation of Article 1, Section 8, Clause 17. Like colonial days, they've imposed martial law rule, which is why we took up arms in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and estimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. With a bankruptcy emergency, it's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session June 5, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all governmental offices, officers, and departments. And as further evidence, the United States federal government exists today in name only. That's U.S. congressional record. And this is a U.S. Senate report. Notice the date, March 9, 1933. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, or assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. The majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19, 1973. And that's still the case. Nothing's changed. Martial law, although Trump is trying to put a stop to it. Martial law rule is a law of emergency and necessity. There's three kinds of martial law. Full martial law when they invaded by a foreign enemy or insurrection, troops are put on the street. Martial law proper, law of the armed forces when a sergeant tells a private what to do, enforced by court-martial. Martial law rule, the law of emergency or necessity used during peace times, can go on indefinitely. And that's Ex parte Milligan, and also Diet versus Turner, and the non-ratification of the 14th Amendment by Judge A.H.L. of the Utah Supreme Court. The private Bar Guild is here to enforce the martial law rule for the Pope, and the Pope's Bar Guild clergy members on the bench tell you I can do anything I want in this court. And this is, again, Diet versus Turner. It says, this is a war of the intrusion of the civil law upon the common law. The court in Diamond v. Harris calls the civil law, the statutory law, superior equity. It's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt a civil law, even though it has the merit of superior equity. In the meantime, civil law is a form of law imposed on the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equities, to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, it follows its own course rather than following common law, thereby destroying the common law and leaving what's called equity in its place. Because normally, equity follows common law, which is taken from the Holy Bible, but under the Pope's martial law, there is no common law because it's superseded and replaced, and also talked about in the Cause and Necessities for Taking Up Arms, 1775. And we've already read this a couple times. But the law of the land in America is common law because of our Christian religious beliefs. Every system of law known to civilized society generated from or has as its component one of three well-known systems of ethics, pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It's the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled, which makes it satanic. And the Pope's private Bar Guild clergy Satanists are using the Pope's ecclesiastical canon Roman civil law of capitis diminutio, the highest and most comprehensive loss of status, capitis diminutio maxima. This occurred when a man's condition was changed from one of freedom to one of bondage. When he became a slave, it swept away all the rights of citizenship and all family rights. Under the Commerce Clause, Article 1, Section A, Clause 3, to assault people with their penal action for breach of quasi-contract. Penal action is an action on a penal statute, an actual recovery of penalty given by statute. Where an action is founded entirely upon a statute, its only object is to cover a penalty or forfeiture. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, remember that word, imposed and enforced by the state for a crime and offense against its laws. The noun penalty is defined as forfeiture, to be forfeited for non-compliance with an agreement. It's breach of contract. That's why it's a quasi-contract. The words forfeit and penalty are substantially synonymous, which is pecuniary punishment for non-compliance with agreement, all tied to the Pope's ecclesiastical Roman canon civil law with the Pope's quasi-contract ecclesiastical pecuniary cause. Pecuniary cause, such as arise from the holding of ecclesiastical dues or the doing or neglecting of some act relating to the church, whereby damage accrues to the plaintiff, towards obtaining satisfaction for which he is permitted to institute a suit in the spiritual courts. Such, for instance, are the subtraction or withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy, as pensions, mortuaries, compositions, and the like. And that's Blackstone's commentaries, quoted in Holthouse, A New Law Dictionary, 1850 edition. To populate the Pope's prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. The Pope's clergy in the low courts are subjecting the petitioner to the satanic religious ceremony with their fraud, lies, deception, necromancy, and idolatry. In violation of Article 1 and Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's Federal Bureau of Investigation refuses to investigate, and the Pope's United States Attorney refuses to prosecute with their weaponized Department of Justice. It should be renamed Department of Just Us, because they intend to engage in war crimes in violation of Article 33 of the Geneva Convention relative to the protection of civilians in a time of war of 1949 by taking reprisals against the petitioner for political beliefs and religious beliefs, evidencing that the Pope's owned and operated United States has no intention of prosecuting anyone for war crimes unless it happens to fall within their political agenda. Trump even paid off the Pope when he commuted Roger Stone's penance, or sentence, no, it was penance, which was changed into a sum of money to be applied for pious uses. Penitentiary. Penitent ordainer of penances, a place for penitence. Penance is a punishment imposed for a crime by ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied to pious uses. You can buy them off. And because of the administrative legislative proceedings under the Pope's Roman civil law, there are more people in prison in Texas as a percentage of the population than there are in communist China or the Soviet Union or the worst dictatorship in history. The Innocence Project estimates that 60% of prisoners are innocent, but it's such good business for the Pope and their ecclesiastical Roman civil law so-called courts, which is one of the grievances in the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. Why do you think they're saying that? It's because they're putting them into prisons. All of this is planned and orchestrated by the Pope from the very beginning. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, March 5th, 1903. Because the Pope was responsible for the War of Independence, and the Pope is responsible for what's happening today. The Pope now owns and operates the bankrupt 1871 Ecclesiastical Municipal Corporation, 16 Stat 419, because when any corporation goes bankrupt, it gets seized by the creditors, as evidenced by the Roman Achaea military staff that is carried in battle by all Roman commands and planted on all conquered nations, that is sitting on the right side of the speaker's podium, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man. They're on the wall on each side of the speaker's podium in the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers, all of which evidences the fact that the 1871 Ecclesiastical Municipal Corporation, currently operating in the District of Columbia as the Pope's dependent city-state, see the image, well, actually it's above, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities. Vatican city-state and criminal matters that talks about concurrent jurisdiction over other states, which means other papal states like the District of Columbia and the City of London, United Kingdom Crown. So let's go back to here. So this is the Roman Achaea military staff right here. And these are the two Roman fascias sitting on the wall. And that's the speaker's podium in the U.S. House of Representatives. Okay, so, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city, state, and criminal matters that talks about concurrent jurisdiction in other states, which means other papal states like the District of Columbia and the City of London, United Kingdom Crown. And this is what it says: when the same matters are prosecuted in other states, The provisions in force in Vatican City State on concurrent jurisdiction shall apply. And that's apostolic letter issued motu proprio, entered into force on 1st September 2013. Which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's minor estate, fiction of law, and the Pope's fictitious quasi-contract, and the Vatican's Pope Francis came and addressed his own and operated Congress on 24 September 2015, and the Pope's private bar guild clergy members are assaulting people like the petitioner with their ecclesiastical fiction of law, minor estate, sesticate use, usufruct trust, necromancy, with presumption of jurisdiction, presumptions of the office of trustee because of the sesticate usufruct minor estate, and presumptions of suretyship. The petitioner has served literally thousands of registered mail notice and demands in an effort to defeat those presumptions, to petition the government for a redress of grievance and exhausted administrative remedies, which why they have targeted the petitioner with their targetedjustice.com website agenda. As posterity, the petitioner is entitled to common law, not Roman canon law by right of blood, as described in Article 6, Clause 2. This Constitution for the United States of America is the supreme law of the land. This Constitution and the laws of the United States shall be made pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. And also is found in the Judiciary Act at 1 Stat 77, saving to suitors in all case right to common law remedy where the common law is competent to give it. And in the Judicial Code of 1911, all causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right to common law remedy where the common law is competent to give it. Article 6, Clause 1. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under the Constitution as under the Confederation. Because the Northwest Ordinance was adopted just 3 months prior to the Constitution, which defines the nature of jurisdiction in federal territory. In Section 14, be it ordained and declared that the authority aforesaid that the following articles shall be considered as articles of compact between the original states and the people, and the states in the said territory, and forever remain unalterable unless by common consent. This is, if you're in those, especially if you live in the Northeast somewhere, this stuff is great stuff that you can use. The inhabitants of the said territory shall always be entitled to benefits of writs of habeas corpus, trial by jury of judicial proceedings according to the course of the common law. No man shall be deprived of his liberty or property, but by the judgment of his peers or the law of the land. And should the public exigencies make it necessary for the common preservation to take any person's property or to demand his particular services, full compensation shall be made for the same. Because the law of the land phrase is convertible phrase with the phrase common law, and this is Book 16, American Jurisprudence, Constitutional Law, Section 543. The principle that no man should be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in Magna Carta, sometimes referred to as Chapter 29, confirmed on the 19th day of June, 1215, declared, no freeman shall be taken or imprisoned or seized or outlawed or exiled in any ways destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or by the law of the land. It's even been said that the principle was known before Magna Carta, and that was originally designed to secure the subject against arbitrary acts of the crown and to place him under the protection of the law. It's settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law. It's been a fundamental rule in the common law. And common law and law of the land has always been here long before the government was here. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. That's long before Hale versus Henkel. And because the Pope's maritime codes only apply on the high seas and up to the high water mark or the first bridge of any navigable river, and the District of Columbia or any federal enclave, Article 1, Section 8, Clauses 17 and 18. The petitioner has been very vociferous about being posterity, as found in the preamble, a living man, a living soul, in every document filed into the case, evidencing the prejudgment on behalf of the Pope's private bar guild members on the bench, the Pope's clergy, and their Vatican handlers, because it fails to matter what the petitioner says or does. This case was prejudged from the beginning using trust law by the Pope's clergy, because trusts are things and fail to have rights, and the Pope's clergy can and do anything they want. The petitioner demanded the County of Montague produce a bona fide contract or be guilty of felonies, and the Catherine Phillips noticed the demand, and they failed to produce any evidence of a bona fide contract or even answer. And the Pope's clergy in the lower courts failed to produce a contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. All courts are required to presume that no contract exists because none have been produced to this date. If the record does not show on its face the facts necessary to give jurisdiction, they will be presumed not to have existed. The law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. The resolution of Congress says that because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3, 1940, at 54 Stat 178, says in the preamble, where it's desirable for the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And as affirmed by Harold M. Stevens, Chief Judge of the U.S. Court of Appeals for the District of Columbia Circuit, in his article in the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon some subjects, how can they intelligently participate in the determination of pertinent national policies? Which means the County of Montague, corporate ringleaders under Roman canon law, may be engaged in treason to the Republic, as well as the private bar guild members may be giving aid and comfort to the enemy in the time of war, because we are attacked by the communist Chinese, the Venezuelans, the Cubans, the Serbians, and others with the 2020 election theft and the fake pandemic and the forced medical experiment, with their communist agenda to implement the first plank of the Communist Manifesto, the abolition of private property rights, with their theft of the petitioner's land in this case. The County of Montague Ecclesiastical Municipal Corporation and their private bar guild members, as well as the weaponized Federal Bureau of Investigation, as well as the weaponized Department of Justice, and the Obama administration and Biden administration are making war on we the people of and the Republic, just like the Pope's crown did, precipitated the War of Independence. He's abdicated government here by declaring us out of his protection and waging war against us. The communists and the FBI made war on the Republic by using sovereign citizen as a buzzword for persecution and prosecution, and then circulate numerous news releases stating that all sovereign citizens are terrorists, as found in an ABC News article entitled Sovereign Citizens Terrorist Assessment Warns of Rising Threat from Anti-Government Extremists, by James Thomas on 30th of November 2015, and in a news article on RT.com entitled Sovereign Citizens Seen as Top Terrorist Threat by U.S. Law Enforcement, by Brian Blanco on 5th of August 2014, and numerous other articles by stating they intend to murder any sovereign citizen without a trial, without due process, by Obama's order followers, and then they proceeded to do exactly that. They issued the findings, conclusions, and recommendations of the United States Magistrate Judge and then approved it, and they're required to issue a findings of facts and conclusions of law, which means it has nothing to do with facts or law, which means they're deliberately and calculatedly legislating from the bench for their bill of pains and penalties, and they've exposed themselves to be the Pope's clergy. And these I've already read before. They in the lower courts have presumed that the petitioner is a minor state. The power to create presumptions is not a means of escaping from constitutional restrictions, in spite of the fact that the petitioner says he's a living man and fails to be their sesticate usufruct on everything under penalty of perjury, and has for many years. Their bill of pains and penalties are unconstitutional act and a nullity. An unconstitutional act is not law. It confers no rights, imposes no duties, affords no protection, it creates no office. It's in legal contemplation, as inoperative as though it had never been passed. An unconstitutional law is void, and it is as no law. An offense by created it is not a crime. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. They unfiled 78 criminal complaints that the petitioner filed into the case in support of the weaponized Federal Bureau of Investigation refusal to investigate them, in support of their targeted justice.com agenda and weaponized Department of Justice, Just Us, to refuse to prosecute felonies as targeted individuals like the petitioner and hope the petitioner will exercise his right to resist their unlawful arrest and their unlawful theft of the petitioner's land and their forced slavery with lethal force if necessary, as evidenced by the Amistad. So they will have an excuse to murder the petitioner and say they killed another sovereign citizen in support of their war crimes agenda, to take reprisals against anyone who thinks they have rights for their political beliefs, and in support of their communist handlers to eliminate private property rights, all of which is in support of the Pope's private bar guild and their Vatican handlers who love satanic blood sacrifices to the Roman cult god Baal, so they can pillage the fake money from the Treasury Direct account under the GlennWinningham firm under the Hague Convention concerning the international administration of the states of deceased persons, concluded 2 October 1973. And the petitioner is not suicidal, but if the petitioner does turn up dead, this is deathbed testimony. Therefore, whether they enslave the petitioner or kill the petitioner resisting their slavery, either way, it's a win-win-win scenario for the Pope. The Pope's clergy evidently intend to perjure their oaths of office to the supreme law of the land under the Pope's Code of Law for the District of Columbia, now known as the Pope's United States Code 28 U.S.C. 1453. Each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I do solemnly swear or affirm I will administer justice without respect to persons and do equal right to the poor and to the rich, and I will faithfully and impartially discharge and perform all the duties incumbent upon me as whatever it is, judge or magistrate judge under the constitutional laws of the United States, so help me God. And have demonstrated they have no intention of being neutral, unbiased, or unbiased. It's a fundamental right to a party to be neutral and unbiased. To have a neutral, detached judge preside over judicial proceedings. And they cannot use their presumptions to escape their oath of office requirements under the supreme law of the land. The power to create presumptions is not a means of escape from constitutional restrictions. The petitioners filed bar grievances against 98 of the Pope's private bar guild clergy, some more than once, and they've all been dismissed as an inquiry, and they were all appealed to the Pope's Board of Disciplinary Appeals, and they were all dismissed again. The petitioner filed judicial complaints against more than 50 Texas judges and the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. Only an Article 3 court can make decisions about life, liberty, or property. Justice Thomas concurring cases involving deprivations and transfers of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts, which has been previously affirmed numerous times by legislative inferior courts. Where controversies of such a character as to require the exercise of judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal or, of course, in any executive officer or administrative or executive board, since they are incapable of receiving it. Therefore, they're acting with no authority and maliciously. Although probable cause may be inferred from malice, malice may not be inferred from lack of. No. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. And both the 97th District Court and the Northern District of Texas failed to be Article 3 courts because government employees, Catherine Phillips and her County of Montague employees, do not get an Article 3 court. Therefore, we decline to rule the opinion of Chief Justice Marshall. The District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens even when one of the several states as the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. Evidencing that even though they were not possessing the power to abrogate the law, nevertheless willing to derogate from it under the pretense of doing equity in support of their intent to be a legislator with their legislative usurpation of the bench and their unconstitutional bill of pains and penalties, because the County of Montague Ecclesiastical Municipal Corporation is in the Pope's owned and operated ecclesiastical municipal corporation called United States, which is operating in the District of Columbia under the Commerce Clause, and they're making the petitioner the Pope's minor estate. U.S. District Court is not a true United States court established under the Constitution to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 to make all needful rules and regulations respecting the territory belonging to the United States. Therefore, they fail to be Article 3 court, but are instead Article 4, Section 3, and they're not competent to make a ruling about the petitioner's life, liberty, or property, which includes land, and their decision is a void judgment, and the judges in the lower courts have exposed themselves to be the Pope's clergy, and the petitioner filed a notice of void judgment into the case. Because the Pope's clergy in the lower courts seem to be always finding an excuse to ignore their oaths to the supreme law of the land, the petitioner has been forced to file an affidavit of life and mandatory judicial notice of 12 presumptions, true copies of which are attached hereto in the appendix of tabs 10 and 9, respectively. But the petitioner doubts it will make any difference because they are Pope's clergy and have no interest in justice, but are instead engaging in justice for their Vatican handlers and are Satanists. You're of your father the devil, and the lusts of your father you will do. He abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he's a liar and the father of it. But the fearful and unbelieving and all abominable and all murderers and whoremongers and sorcerers and idolaters and all liars shall have the part in which burneth with the fire and brimstone, which is the second death. The Pope's 1871 ecclesiastical municipal corporation operating under Roman canon law in the District of Columbia is unconstitutional, as well as the Pope's minor estate, now codified at 31 CFR 363.6, and the Pope's private bar guild, foundation of the Federal Bar Association and all its subsidiaries in the various states, because they're all violations of Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because there are laws respecting the Pope and the Vatican and the Holy See, and they're subjecting the petitioner and all the people are dealing with to their satanic religious ceremony and their fake court cases and their fraud, deception, lies, necromancy, slavery, idolatry, and human trafficking, and the Pope's foundation for the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35 U.S.C. 70501 through 70512, is a violation of the Definitive Treaty of Peace of 1783, Article 1, which is the supreme law of the land under Article 6, Clause 2. Almost done here. Findings and conclusions and recommendations of the magistrate judge and the ruling of the 97th District Court are each a bill of pains and penalties, legislative usurpation of the bench against the named petitioner, and violations of the bills of attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. The County of Montague, Roman Canon Law Municipal Corporation, in conspiracy with the Comptroller of Texas and the Private Bar Guild in Texas, and the attorney with the rank of general are bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. The writ should be allowed because it's nationally important, will affect almost everybody and all governmental entities in the country. The Pope's minor estate are in place for almost everybody, and almost all governments have established the Pope's municipal corporations. And the Pope's bar, British accredited regency, is a source of corruption because of their lack of Christian common law ethical standards and a violation of the Definitive Treaty of Peace of 1783, Article 1, which is the supreme law of the land under Article 6, Clause 2. And that's the end of it. And notice, fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to be representing the Pope's minor estate. And then that's it. And then there's the appendix. So I don't think I want to go through this appendix. It's, we're on page 53 right now, and there's a total of 334 pages. So I think we're about done now. Does anybody have any questions?
I noticed that you put in Trump's name in there twice, so we're going to be not serving him, but sending him.
Yeah, I'll send him a copy of this.
Good.
I've already sent him one, but now that I'll be filing it again, so I'll send him another copy.
Yeah, that's your obligation, right?
Well, on worst comes to worst, I'm hoping that he'll keep an eye on it, and if the Supreme Court doesn't rule in my favor, that he'll do something. There's remote viewers that saw Congress adjourning for the last time, and so I think that's what's going to happen. Whether it happens because of what I do, or maybe it's just something Trump does. I don't know.
It was interesting that the state congressman went to your township to talk about the depletion of taxes, though.
Yeah, well, that was Abbott. He's the governor of Texas.
Yeah, how long ago was that?
A few days ago. It was like within the last week.
Yeah, that's pretty good timing. No, Trump's been doing some pretty incredible things as far as shutting corruption down. I heard a way huge number of 1,600 centers where children are being housed. He's closed them all down, apparently, and all the children have been recovered alive and are in safety. So 1,600 of these safe houses around, well, I'm sure they're not all around the United States, but he's doing some incredible things that I'm thinking is sparred all these early Christmas or these holiday takeoffs. All their offices are now closed. Here.
It's hard to say. I think that right now he's focused on the stuff in Venezuela, because there's the stuff I'm hearing is that it's more and more stuff is coming out about Venezuela stealing our elections, and has been for the last 20 years, and so it's Venezuela, China, Cuba, and that's why that shit's going down in Venezuela right now, and I think we're getting ready to invade. But so we'll see what happens. My understanding, and I'm certainly, I don't know everything, but my understanding is that that we're going to that we went and got there's a legitimate president of Venezuela that we got out of there. So they were, you know, how would you put it? Free from harm's way. Let me put it that way. And while we take care of this stuff, and we're going to, because you basically have a bunch of gangsters that are in there and have taken over the government, and so we'll see what happens. That's all I can say. We're all a captive audience, but um, I have no idea. All I can do is I like watching. There's a lot of Patrick Byrne videos out lately, and I would suggest you watch those. And then 107. Those are the two ones that I find are the best to find out what's happening. And General Flynn. General Flynn is a wonderful guy. I really like him. And so, anyways.
You notice that I put in that update or the latest video by Todd, the gentleman who has the mother as the father as the banker and the mother as the judge. Or he put out a latest video, so I put that in your room.
I saw that
this week. Oh, good.
I saw that. I downloaded it, and and there's going to be another one here pretty soon. They're going to have a video on how to deal with it if you get arrested. And I heard that he got arrested too. He got arrested. They had him in jail for like about 3 hours, and then they kicked him out of there.
Well, they took him that far, eh? We'll see where he takes that, I guess.
Yeah, that's right. Yeah, well, that's interesting. I know there's guys that I know that have been looking for his information for like 20 years, and they're very excited to get that information, and they're going to start using it. I'll tell you, I'm going to start using it. I'm going to file a notice of intervention into a case and then start bringing that stuff up. And so, where's the accounting? I want to see the accounting in this matter. So we'll see.
Exactly. So what prompted you to do these amendments now and not wait for you to get your reply or your doctrine letter?
Well, I just like to get it done so then I don't have to worry about it. Otherwise I got this thing hanging over me all the time, and I want to get it done so that I don't have to worry about it. That's my big thing. And then I can focus on other stuff. Once I get this thing in the mail and they've accepted it, if I get it, especially if they send me a docketing letter, they'll send me back the other one probably, and then I'll be stuck with all this paper. But at least I'll get this done, and because they've had plenty of time to send it back if they were gonna. I'm just surprised. I think that they're hoping that I'll make some changes, and which I did. I made some changes. I actually toned it down, although it doesn't look that toned down, but I did. I toned it down.
No, you did. Yeah, you took out the statements about if you show up dead. I don't like that statement that you had in there a few more times than what it is now. So
yeah,
it's true. It is true.
Yeah, I thinned it down. So, anyways, I think they want it. I think that they want it. I think it's it's going to be maybe I'll go down in history or something. The guy that overturned that stuff. So we'll see. That's all I can say.
Well, I'd like to see you with your land back in your possession.
Yeah, I'm looking forward to. Well, I haven't. That Montague County has gone silent. I got to tell you that. I haven't heard a peep out of them. And now I filed this lawsuit over this recent arrest, and I have in there I want $300 million, but I'm doing an amended one here, and in there I'm telling them it's going up. It'll be like $700 million, and so because it's $10,000 a day with the That New Jersey rap,
Incarceration.
huh?
With the incarceration.
Yeah, it's $10,000 a minute. With Rab versus Ocean City, the precedent's $10,000 a minute in 2016, and so $10,000 a minute. So that's like, $600 million.
If that's a case, if
Yeah,
that's a
that's
case, raspberry. What?
Rab versus Ocean City. Let's see if I'll let me find it. I'll put it in the text.
Yeah, put it in the chat. I appreciate you.
Yeah, it's Rab versus Ocean City. Let me find that. And then I got to start serving this one too. I got to start serving this one.
Are you going to be able to serve it electronically to everybody?
Sorry?
Are you going to be able to serve it electronically to everybody, or?
No, I don't do that. It'll go. I don't do electronic. So I'm putting it in. I'm putting it in the text on my. It's called on my page. It's called Rab versus City of Ocean City, and if you look it up, you'll see that it's $10,000 a minute. And so that's a good one to use. And it's 2016, so it's fairly recent. Anyways, if that's it, if nobody's got any more questions, I guess we'll adjourn till next week, same time, same place, same channel.
Okay, don't be late. You know the rule. You know the rules.
I'll have. Well, we'll see. I'm doing an amended petition, and so I've got some people helping me with it too. So we'll see. Although they haven't said anything, I think they like it. And I've got this notice. We talked about it last week. The notice of constitutional challenge for Texas joining the union, and also for the minor estate. So the minor estate might be a moot discussion if this Supreme Court case, if they hear it and make a decision, then it might be a moot discussion. But there's Texas joining the union too, so I might go down in two cases, go down in history. So we'll see. That's all I can say. I have no idea what's going to happen. I wish I did. I wish I could predict the future, but so
it's in God's hands.
Yeah, it's up to God. I leave it up to God, and if God wants it to happen, then it'll happen no matter what happens. You know what I mean?
But you were the originator of that document, so you will be credited.
Well, my name will be on it, that's for sure. But I'm just a tool. I'm just someone that God's using to accomplish His objectives. I think that I'm just a tool.
Facilitator. I like to use that word better.
All right, you guys take care. We'll see you next week. Same time, same place, same channel.
Okay, have a good weekend. Let me know if anything comes in.
What time do y'all start on here?
Usually it's 9 o'clock Central Time, which is 10 o'clock Eastern. But it's live streaming on YouTube, so you can go to YouTube and watch the live stream.
Okay, thank you.
Okay, send me my cut.
Send you your cut.
Yeah.
What cut is that?
For your YouTube.
Oh, the link to the YouTube video? Sure.
Look, you made a whole bunch
So
of super chats.
is it recorded on YouTube so we can go back and watch it?
It's a live stream on YouTube, so yes, it is recorded.
So where do I go and watch it at? What's the name of the channel?
My channel's called Sovereign Living.
Okay, got you.
Okay, Glenn, thank you. Have a great night.
All right, you guys take care. See you next week.
Bye now.